May I mention a death row matter, Your Lordship? He's been a death row matter. He's been incarcerated for more than 30 years. He's been on the death row for about 19 years. I'm requesting for listing, Your Lordship. It is to be listed before a 3-judge bench. We had moved an early hearing application in which an order was passed.
Give the particular.
Yes, Your Lordship. Your Lordship is also sitting in a 3-judge bench this week, Your Lordship.
My lords,
Much obliged. Much
may
obliged.
I mention item 25, my lords. This is a bunch of civil appeals. Mr. Kapil Sibal is leading Meta Platforms in the matter. He's taken ill, so we are seeking an accommodation of another week, my lords.
Just give your note, please.
In fact, my lords, I am also mentioning on behalf of Mr. Kapil Sibal for a matter which is...
We have informed.
In the Meta matter.
Mr. Sibal is not well. He spoke to me. He is unable to speak.
No objection. No, obviously no.
So you don't want to be taken up today.
But it listed today. He is mentioning it not for next week. Sibal is not.
Well, if none of you have any objection, you can take up next week.
I've also filed an intervention application on behalf of All India Small Industries Forum because we're all using WhatsApp business accounts. So we have got to say something.
Anyway, your
We have 4 crore users are there.
You are seeking impleadment in that.
Yes.
If they have no objection, we can implead. You also,
WhatsApp business is very important.
well, let's say application for say IS so and so allowed to the extent that the applicants are permitted to intervene and assist this court.
Yeah.
The short affidavit, if any, may be filed within by Friday.
Your Lordship listed not Friday week.
We'll actually
He cannot come not for a week, 10 days. So not Friday week, not this Friday, but next Friday.
The 20th.
I see.
20th. If it pleases the court.
Then should we take up on 23rd, Monday?
No problem.
Very well.
And we on 24th then because too many SLPs will be there. That's why I'm suggesting.
23rd, the only advantage, Monday is miscellaneous day.
And your
So at least
So let it come on a Monday, then your Lordship take a call.
Yes, but your lordship has listed this only for.
we will accommodate you. If you are busy in the other course, we will accommodate all.
That's it.
And your lordship has listed right now only for consideration of interim. For Friday, your lordship has given another date.
Correct, correct.
So, what is the main date in the main case then?
Your lordship has given it April.
Yes.
15th April in the main matter. In the main.
So 23rd will only for that.
Consider me not on 23rd.
Whatever proceedings were to take place today, those will now take place on 23rd February. That's all.
Obliged.
With your permission.
My lord, with your permission,
per-
my lords, may I mention item number 33 in tomorrow's list, my lord. Same Mr. Sibal is appearing and he's not well and we'll be seeking.
What happened to Mr. Sibal yesterday, the day before?
He's not well and I think he won't be, it's like very bad viral fever he has got and.
Because of the change of weather or might be.
Yes, my
Yesterday
lord.
I saw him appearing in some function, he was there. So I just thought that he's fit and fine.
No, he is.
But anyway, that throat problem, he must take some rest.
Yes, my lords. My lords, I've informed the other side. It's for listed for tomorrow, my lords. I'll be seeking an adjournment.
The lawyer's problem is otherwise. They are good only when they speak too much.
Yes, my lords. That's also the.
A silent throat for a lawyer
my
may be
lords.
it can become a cause of ailment.
Well, I was just one request. This matter has been pending for substantial amount of time.
Please
And the
come here.
process has,
Warm wishes to him for, we pray for his speedy recovery. Throat is something that, yes, one has to take rest. There is no way out of it.
Yes, my lords.
well, it's just a simple request. If a short date can be given, the matter has been posted for long. And I'm appearing in this matter, ma'am.
This very matter.
Yes.
In this very matter, we have informed
Just
him.
a small request.
Oh,
If
you are
this matter
opposing.
can be taken up on a short date.
Are you opposing?
Yes, my lord.
No, she's not
I'm
opposing.
proposing just if this can be kept for a short date.
But you are opposing a longer date.
Sorry, my
What are you opposing then?
my lord's not opposing. I'm just simply putting a request. If my lords can consider to put it on a short date.
We can accommodate you with the date of your choice, that's all.
Yes, my lords.
Provided that we too have some space on that day. If already there are sufficient matter listed, then there is no use of adjourning condition.
Yes, my
Right,
lord.
my
Keep on waiting whole date and might not come. So have a date when we can also accommodate you. Give a shortest date.
With your
Obliged.
permission, lordship.
Obliged.
Please mention WP Civil 13381 MC Mehta matter. I am the applicant in that matter. I have filed my compliance affidavit.
So
The
right,
report is.
MC Mehta matter I can't take up every day. But I have fixed a schedule. It will be taken up and all the pending applications we are taking one by one.
Your lordship, the project is getting delayed. I have filed my
So
compliance
like,
affidavit.
take out a case of urgency, we will take up. When we list the MC Mehta matter, then we also see that how the IAs or MAs are to be prioritized. We do that homework and then only we list it. So we'll see that if.
Lordship, it is a task-related matter situated in.
Thank you very much. We will give it.
My lords, in the same
Mentioning of,
my lords, in the same matter, the difficulty is that my application for the
you are
army,
making the same mentioning, then why two mentioning?
my lords, the application is different. I'm representing army.
All right, thank you. We are listing MC matter. Will not.
My lord, just a humble request. My lords, the date was showing like 10th, 9th and 10th, but it was not listed. My lords may fix a date and my lords.
Whatever the reason, whatever the ground, we will see it when to be listed. Thank you. Thank you very much.
My lord, may I mention one matter which is very urgent? My lord, while I was appearing on the last Saturday in the Calcuttahighcourt, in the court of ADJ Harjit Singh Pal, in the court of ADJ Harjit Singh Pal, where I was appearing on behalf of the accused, and my lord, the opponent, the complainant's advocate, along with many goons, entered into the courtroom. In front of the judge itself, they immobilized me, hit me, and all the accused inside the court were two.
Hit you as a counsel or they hit the.
I was a counsel. I was a counsel of the accused person.
You were assaulted.
I was also assaulted along with the accused person also assaulted. And thereafter, they locked the door inside the courtroom. Judge was sitting right there. All the members of the courtrooms were there. Police officials were there.
You are bringing this matter to when it happened?
Last Saturday on the 7th.
On Saturday. That means day before.
Day before, my lord.
Today is Monday.
Today is Monday.
Have you brought to the notice of the Chief Justice of Delhi High Court?
No, my lord. Actually, nobody is supporting. Police is so scared they are not even ready to provide
Forget
the
about
security.
If you can make mention before me, why haven't you made mention before the head of the state judiciary, Chief Justice of the Delhi High Court?
My lord, I have seen that due to the past incidents in the Calcuttahighcourt, nobody is touching this matter because it is against. So I am the member of the Supreme Court Bar Association.
Don't decide you are you mentioning so that media can catch up it?
No, my lord.
Then, have you made any written complaint to me?
No, my lord, this is a written
Please
complaint.
go make a written complaint to the Chief Justice of the Delhi High Court during the course of day and send a copy to me. Inform my PPS that you have made a complaint. Then let me deal with on administrative.
My lord.
Nothing to be done on judicial side. I will deal with it. But first you go and make a complaint. Let the Chief Justice take cognizance of it.
My lord.
If the police is not, that means that there is no rule of law. You make a complaint, give a copy to me and tell the staff that you have made a complaint there.
My lord.
How can they misbehave like this? This kind of Gundaraj Kant is not acceptable to us.
My lord.
Go and make a complaint immediately to the High Court. Yes, let us start.
May it please your lordship. May I request your lordship may take up the paper book of item 20, which is a.
Yes, item 1, 20 and 41 are same.
Your lordship. May I see the paper book of item 20, because this is a case where.
You have already dismissed it. No. Notice in a similar matter, issue notice. What is the next date in that matter? It was on 29th January.
20 is
My
also
lord, it is
listed
in
today.
fact listed
It is listed today, my lord.
today.
Item 20. which
All
has
the
come up
pleadings are
after
completed.
It is
All the
item
pleadings-
12.
Yes, my lord, because.
Are you appearing?
Yes,
So then please, would you like to file any counter in that matter or what?
we have, all the pleadings are completed from all sides. And my lord, in fact, we are ready with the note.
So then wait, we'll take up this matter along with item 12.
So notices will have to go in item number 1, 1.1, 1.2, 1.3.
My lord, issue is one and the same.
1.
Issue is one and
Issue
the
is
same,
the
my lord, on all the matters. 1 and 20 and 41. It is only, my lord, 2023 notification
The
of.
issue is very simple, that even if it pertains to the recruitment to judicial services, can the High Court assume the role of the subject experts? That is the issue.
And
Am I right?
That is one. That is one, my lord. Number two. My lord, when the
There
High.
is nothing like number 2, only number 1.
High Court is 134 is the total control of the entire judiciary recruitment and malad. Then how the my lord, Public Service
So
Commission is agreed.
if a learned judge, suppose he masters in mathematics, and tomorrow the question of some mathematics question comes, why he should not review that also? Because he knows that subject, like law. The other brother or sister judge can be maybe that he is BSc in biochemistry. So the question of biochemistry may come. Why not that also? Because he is a High Court judge.
A question of law, constitutional issue, my lord, now we are.
So we are only on the question of law. If you want us, we can remand the case to the High Court. If you want us to decide, we will decide it. But we have hinted you what is the question in our mind.
Your Lordship, my prayer would be.
अरे भाई आपकी फेवर में बोल रहे हैं ना अभी तक तो आप थोड़े 2 मिनट चुप रहिए. So sir, please guide us. What is to be done?
But it can be heard, my lord, my lords may.
We have heard it. You answer it. Question is very simple. That under the law
Yes.
and whatever the precedents this court has laid down, should the court assume the role of super examiner
My lord, it is like this. My lord, the
only on the presumption
yes.
or assumption that the question paper pertains to law, recruitment pertains to judicial services, and therefore the High Court, as anybody would like to assume and presume, High Court is in a well equipped as compared to the examiners. If this is the principle you want to lay down us, then sir, it becomes very dangerous.
My lord, it is the Public Service Commission. My lord, after issuing the revised key, my lord, sent it to my lord
The High Court can
administrative
always
file.
say, the High Court can always say that this question seems to be incorrect, the answer key, and therefore we refer the matter back to the Public Service Commission. Public Service Commission may constitute another independent body of experts. They may revisit it. This is the only law.
Your Lordship.
Your lordship.
This is the legal principle well settled.
Your Lordship.
If you want, we can do it immediately. Let's not, because unnecessarily, otherwise it will delay unnecessarily.
Lordship is
All right, right. दोनों item का है. Item 12.
Your lordship.
Lordship, there is an intervention application in this matter, item 20. Counsel is appearing online, Lordship.
120.
Is my lord referring it to independent committee?
Independent of this.
That can be closed? Matter can be.
Lordship,
Yes.
Lordship, there is an intervention application on behalf of High Court.
We are allowing High Court on behalf of the High Court.
High Court of Jharkhand, kindly unmute, counsel is appearing on.
All right, all right. You are the counsel before us. You argue.
Lordship,
We are a bit conservative. We are not very fond of online, so you argue. Now, give the mic. Give the mic to the young lady.
Lordships, there is an intervention application on behalf of Honorable High Court of Jharkhand. Honorable High Court of Jharkhand is a necessary party in this matter, Lordships, as the answer key was finalized from the High Court of Jharkhand for the judiciary examination, which is in dispute, Your Lordships. So kindly allow Your Lordships to High Court of Jharkhand to become a party in this petition, Your Lordships.
So if the answer key was prepared by the High Court, in that case, the direction can be to both to the High Court as well as to the Public Service Commission. Both will examine it. Both will revisit it. And High Court as a neutral umpire should be in the middle, not on left side or on the right side. Because courts are normally always on the right side, they have never on the wrong side. But in such like matter where you are a litigant, it is always ideal that you are the neutral umpire in between.
Obliged. Kindly make us a party, Your Lordship.
But are you right? This is the legal position.
Yes, Your Lordship.
Do you agree with the observations tentatively we are making with respect to the settled principle of law on this subject?
Your Lordship, High Court will make its submission in due.
We will say High Court has also been heard. ये allow कर दो भैया. I335854 allowed. The High Court. You want to now respondent or you want petitioner? You want a respondent.
Precisely, that is the difficult part.
So you said middle point here.
High Court is not saying anything on administrative side. Well, in fact, on administrative side.
Micus. Say IAS once allowed, the High Court of Jharkhand, through its Registrar General, is ordered to be implemented as a response number 1A. Or say, both are state 1 and 2. Then say 2A as response number 2A. Say leave granted. The issue that calls for consideration is whether the High Court of Jharkhand, in exercise of its power of judicial review, rightly interfered in the answer key published on 13 May 2024 in relation to for the answer key of the preliminary entrance test held on 10th March 2024 for recruitment of civil judges in junior division. The aforesaid preliminary examination was held pursuant to advertise number 22/2023 dated 14th August 2023. How many? 3 questions or more?
Yes,
3 questions. Question 8, question 74.
Well, in fact, I have prepared everything, notes and the dates and the events. My lord, so please explain it, I'll finish.
The High Court, through the impugned judgment, has opined that answer key in relation to question number 8,
74 and 96.
question number 74
And 96.
and 96 was erroneous and as such
And paragraph 36. Paragraph 36.
Any question?
Finish.
the impugned judgment, has concluded in para 33 that the key answer given by the appellant publisher distribution to questions number 8, 74 and 96 in booklet capital A are incorrect.
36. 36.
The High Court has directed to give 1 mark to the candidates who answered to option in bracket capital A in question number 8 in booklet A and delete question number 74 and question number 17 and 96 in booklet A from consideration. Next paragraph. The High Court, however, while the impugn judgment has held that in the absence of an express provision in a statute, rule, or regulations governing the examination, re-evaluation of the answer sheet is impermissible. Next paragraph. We have heard Honorable Counsel for the Appellant Public Service Commission, Honorable Counsel for the High Court, as well as Honorable Counsel appearing on behalf of the candidates who oppose the High Court under its jurisdiction. Next paragraph. It may be true that the subject examination pertain to recruitment to judicial services, and as such the honorable judges of the High Court, in the very fact, keeping in view their vast experience on bar and bench, are expected to have a better understanding and appreciation of the legal the questions that were put to the candidates in the examination. However, even while accepting it as an undisputed fact, the question remains that the power of judicial review in the matter of re-evaluation, re-appreciation, or reconsideration of the answer key would apply uniformly irrespective of the nature of examination. In this regard, it seems to us that the High Court cannot assume the role of super examiner, stroke subject expert, and such an exercise should ordinarily be left to the domain experts. It appears from next paragraph. It appears from the stand taken on behalf of the Public Service Commission is that the answer key was duly vetted by the High Court on administrative side. It may or may not be side also. If that is so, it is more than necessary that the High Court, while exercising judicial power, ought to have referred the matter to the Committee of the High Court as well as to the Public Service Commission to constitute another committee of subject experts, enabling such experts to revisit the answer key in respect of question number so and so and so.
May include one professor.
High Court ought not to have taken this responsibility onto itself while exercising the power of judicial review. Consequently, we allow this appeal in part to the extent that paragraph 33 and 36 of the interim judgment, 36 and other operative part of the judgment is set aside. However, the High Court has rightly restated the settled legal position that there cannot be re-evaluation of an answer sheet unless the rules, regulations, or policy expressly provide so. Then, for the reasons stated, we allow this appeal in part and set aside paragraph 33, 36, and other operative parts of the impugned judgment the matter is referred to the committee constituted by the High Court on the administrative side to re-examine the answer key in respect of the disputed questions, and thereafter disputed questions and send its opinion to the Public Service Commission for necessary follow-up action. The needful shall be done within 2 weeks. Within 2 weeks. Next paragraph. It is clarified that we have not expressed any opinion on merits of the disputed question or the answer key.
May I only make a request where your lordships have indicated para 36. My lords may kindly include para 39 also.
When you said so, other property, but you can 33, 36, 39 or any other.
Obliged to.
This will apply to item 1, 20 and 41.
But committee may consist of a professor and also subject expert on law.
The committee लिखा ना, the committee comma, the committee may also associate some eminent law professors as domain experts for its assistance and guidance.
Because the entire contention is one of the counters says that judges are not experts in English, so they are experts only in law. Lords may also say expert on English side, also a professor in English side, because they say all the boys was in the room. This
one question pertains to
more than one boy.
One English professor also.
We have said subject experts, so that will include the English.
Well, they may not, your lordship may say English because they specific.
Expert in bracket, one of whom will be a professor in English. Huh?
Deeply.
One of whom will be a
So
professor
glad,
in
because already 2.5 years, my lords, already 2.5. My
That's
lords,
why we have said 2 weeks. We are only giving 2 weeks. We request the High Court to conclude the pending selection process expeditiously.
my lord may say the process of the entire recruitment, because my lord, from September.
Same word we have said recruitment process. You are saying process of recruitment.
The entire process of recruitment.
Entire.
Well, maybe by 3 months for that.
High Court and
because subordinate judiciary, they don't have from 2.5 years, there is no appointment. Already in 2023, it was 138. 2024, 25,
my worry is entirely different. That is one High Court where there is no elevation from the bar since 2017.
larger issue.
And neither any designation methods.
Deep level.
Yes, item 2. I think similar matter is pending, madam.
Yes, my lords.
But you are coming after such a long delay. Notice, issue notice returnable on so and so date, notice recondonation delay. Then after condonation delay, all tag with SLP civil diary number 28480 of 2025.
Obligement.
Lordship, after the election has been declared, the date of election has been declared, substantive rules have been sought to be withdrawn.
What is that change in rule? What is that change in rule?
Yes, Lordship. Lordship, you kindly have page 80. Page 80 is a reproduction of the rules of Bar Council of India Uniform Rules. Now, this is an extract.
It's by mistake, it was not mentioned, so it is not a change of rule. The rule was already existing.
Kindly.
All right, thank you. Anything?
Point out, Lordship, what's the difficulty here? Lordship, will kindly have page 80. Page 80 is the rule. Reproduction of the rule.
Yes.
16.
it says that returning officer shall reject the nomination paper of any person who were or are office bearers of any bar association on the date of notification of the election. Now, this was the rule. Now, after that, on 17th of January, Lordship, we'll find page 81. They sought to withdraw the rules. Now, Lordship finds what is the mandate of the election officer. The mandate which was, which the court directed was to conduct the elections and to facilitate the
Why that was withdrawn? Because the notification is as per 2023 rule. The rule that was
I'm sorry, Lordship.
Come to page 76.
23. Yes.
Come to page 76.
Yes.
Read the first line.
Yes. Notice is hereby given under Bar Council of India rules for qualification, disqualification, and produce for election. And so, Lordship, see, this was a notification, Lordship, does not stipulate.
Sir, the notification is in terms of the latter rules. By mistake and clause of the earlier rule which stood over supervened by these latter rules was incorporated. This error was corrected. This is not changing the rules.
Please consider, Lordship. Please consider for one moment, Lordship. 23 rules did not stipulate this condition. This was in the 2016 rules.
Correct. 2016 rule has been overridden by the 23 rules. So, the notification having been issued under the 23 rule by incorrectly referred to 22 rules, that was corrected by the corrigendum. Where is the change of rules?
So, Lordship will at least consider, Lordship, that
Nothing.
after the election was
Thank you very
notified.
much. No question to be made of dismissal. Item 4, there is a letter circulated.
Please, Lordship.
Milords, in item 5, Milords, the Maharashtra Pollution Control Board, Milords, issues us a direction to undertake the assessment, Milords, the damage assessment for an accident that had happened at our premises.
Yes.
Milords, in terms of that direction, they only give us 3 institutes where we could go and get the damage assessment from. One was NEERI, IIT or VSI. We go to VSI, and in terms of this direction, we appoint VSI for the purposes of.
So one of the expert body has assessed the damage, sir. We are not the mathematician, or we are not the super experts here.
No, Milords,
An expert body, all of you agreed that there are 3 institutions of eminence who can do it. One of them has been picked up by the tribunal. Assessment has been made. Lossy accident, you don't deny.
No.
The molasses spread it over so many areas, spoiled the agricultural land. That is also an admitted fact.
Milords, subsequently, may I just say, Milords, 2 points. Subsequently, Milords, there is a joint committee report of the Pollution Control Board itself, which shows that I have done the remediation work at there, Milords, in the area, Milords. I have done substantial compliance of the remediation of the accident, Milords.
Yes, sir.
Thereafter, Milords, the expert authority or the expert body goes. All I am saying is, Milords, the sampling was not in terms of section 21, Milords. Please, sorry.
Follow the guidelines and then only assess.
Milords, those guidelines also, Milords, do not ask them to take away section 21 of the Water Act, Milords.
Yes.
All I am saying.
You have been given opportunity by letter dated 23/2/2023, after the samples were collected on 5th and 6th of February, notifying you if you wanted one of the samples to be sent to the central laboratory, you could have. You have missed the opportunity. Now,
All I am saying is the sampling was not done in accordance with law.
it was done in accordance with law. The only thing is, your case under 21(2) or 21(3), you had an option to send one of the samples to the central water laboratory or the state water laboratory. You were intimated of the drawing of samples. You were intimated of the fact that this specialized body, which was chosen by you, was analyzing. You did not opt out of that.
Show the conclusion of the body, Milords, just for a minute, Milords, just one page, Milords. Just if your Lordships should kindly come to page 200, Milords. And if my Lords may kindly see at the bottom of 200, they have given a finding in my favor, Milords, of the water.
The authorities will consider that.
No, Milords, but with that, Milords, they've also imposed a damage assessment of 2 crores, which will now.
Very right action.
Remediation being done, Milords.
Remediation and environmental damage costs are different, sir.
Well, it's because we have completed the entire remediation. If your lordships will come to page 200, at 200, the report gives the finding that the sampling has been done and it is correct, my lords, and there is no difficulty in that. The entire remediation has been mitigated, my lords. That's the finding, my lords. Only on this point I was before.
No, please, let's not, because we also know our scope of interference in the law.
Lords, may I then just request, my lords, this may not come in my way to raise the challenge because they are still considering the report on the next date of hearing. Because as far as the amount calculation of 2 crores is concerned, my lords, there
Better
is some
than
kind
you,
of an ambiguity.
better you withdraw with liberty to raise whatever your contention there.
That's right.
After arguing the case for some time, learned counsel for the appellant seeks and permitted to withdraw this appeal with liberty to raise all the contentions before the tribunal.
Please, my lords,
Before the tribunal at an appropriate stage.
I'm so brief.
This is a larger policy decision on behalf of the state of Himachal Pradesh to decongest Shimla. Two, my lords, in this case, we have a much larger premises available in a ready building in Dharamshala. There are a large number of other offices also in case of other commissions and boards which are being shifted. My lords, from the demographic aspect, people find it very difficult because the largest concentration of the backward communities are in the Kangra district. That is also admitted by the petitioners, and in the employees' representation. And there are a handful of employees, they are not going to be moved. The class 4 employees and the lady employees, my instructions are they are not going to be moved. This particular office in Shimla is going to continue functioning as a camp office where some hearings will be held. But, my lord, there can't be a blanket stay.
This order,
Your Lordship, with regard to the fact, my lords,
the High Court will decide where publicity commission should be there, where backward class commission should be there.
Your Lordship, my humble submission is that basically they have not.
Anything you shift from just Shimla to Dharamsala, we understand that when the tribunal was shifted, this state administrative tribunal, you people will go on strike. Why not continue in Shimla? Everything continue. Shimla, there is space crunch. Dharamsala is an alternate place. The assembly also takes place. Your summer, your winter session also takes place in Dharamsala. So, what is the problem if some of the offices are shifted?
It's not about some of the offices, my lords. They have also shifted some another offices. With regard to that, with regard to those offices, the Honorable High Court has not issued an order of stay, my lords. In these two matters, my lords, the Honorable High Court has taken a specific.
Was this petition filed at the instance of this landlord whose premises has been taken on rent for 22 lakhs something?
No, my lords, because.
Then who is the person behind it?
Your Lordship, he is the ex-member of this back.
What is their problem? They are ex-member. They are not supposed to go there.
My lords, they have not even filed.
And who are they to dictate an elected government that where should the office be? It is their prerogative. If you have any problem when the next election takes place, oppose them on the ground. How this issue becomes justiciable?
With regard to the decongestion, my lords, there are only 11 employees, and out of 11 employees, 6 are class 4 employees, my lords. And the building has been leased out, my lords. And there is.
Building has been leased out. When they will shift, they will vacate the building.
My lords,
or they will utilize the building. There is a lot of other offices which require building.
On one hand, they are sealing the.
Why the High Court is unnecessarily indulging in these things?
Your Lordship, because basically why this relocation order has been passed on 3rd December. My lords, in December, the new chairman was appointed. Subsequently, on 24th December, he floats this proposal for relocation. So, this particular relocation order, it is on the behest and for the facilitation of the chairman, my lords. It is this commission is working since 1998, my lords, over there.
Are you aware of you are practicing there?
Yes, my lords.
You know very well.
Yes, my lords.
This your state administrative tribunal has been in Dharamsala. Has been in Dharamsala for all the times. as and when the state administrative tribunal is constituted, it is in Dharamshala only. अरे भाई आपको पता है, मेरे को पता है. I was the chief justice when I abolished it.
It was maybe circuit bench.
And since then the tribunal has not been constituted.
Circuit bench.
Lawyers in Dharamshala have been agitating it. I went there when Palampur court was inaugurated. The lawyers were raising all the demands. Sir, we have been having at least the tribunal, you are not constituting the tribunal. I said, no, as a matter of policy, I don't want a tribunal because a litigant has to go to two platforms. First he will go to tribunal, then to High Court. So why burden the consumer of justice for that? So they agreed, they didn't go on strike, they were happily strike. So today if some of the offices like winter session of the assembly is being shifted to Dharamshala, what is the problem? It is not a court that lawyers will oppose.
Your Lordship,
it is an administrative office of a commission, a backward class commission. The commission will operate, they will have to make assessment in the state. They can do it while sitting in Dharamshala, they can visit other areas also. And Dharamshala is not something in Kinnaur district or where you can say accessibility is poor.
That is why
Dharamshala has better accessibility.
That is why, my lords, the Honorable High Court has cautioned the state that the offices which are having a larger strength, they should be shifted rather than the minuscule, the offices with minuscule strength.
High Court should refrain itself. We are not experts on these things.
My lords, basically this
High Court, we understand. Near the High Court, there is a government building. You suppose have space currents. High Court say this building is lying unutilized or underutilized. Please give it to. We require it. High Court requires for expansion of the courtrooms, expansion of the establishment or anything. Understandable that you raise your demand. How are you concerned how the backward class commission will work?
But if it is for the benefit of only one individual, my lord, it is only for the chairman. Chairman gets appointed on 3rd December.
What is your problem? Yes, why not? If the chairman wants to, as per his convenience, let it be. People will answer it in the election.
In the meanwhile, he has also communicated that a camp office will be started at the same premises. On one hand, they are assailing this order. On the other hand, they are communicating that they
is required in the original office, but because the demographic, Malad, overwhelming, the backward classes are from that area in Malad Kangra. So they will find the access, Malad, much better in Dharamshala.
But if you know very well, it's not so easy to it's not so easy to travel in the remote areas in Himachal. Some of the villages still you can't go in a car. You can't go in a bus. You have to climb down. Then only you can reach there. So for the purpose of accessibility, but when we talk of access to justice, when we talk of court at the doorstep, when we talk of ease of justice, are we not these factors taken into account?
But my lords,
people who are actually backward class, don't they have a right that somebody will come to them, find out, yes, they are living in these conditions, therefore they are entitled to certain benefits of the social welfare schemes.
But with regard to that fact, my lord, from Shimla, they are doing certain other exercises with regard to the elections also.
All right. Anything else?
My lords, they have issued one communication wherein they are saying that the proposed office, which they have earlier allotted for the purpose of this backward commission, now they are saying in this communication that it will be for the camp office. So once they are opening a camp office over there, my lords, so there is no point of shifting the head.
Let them decide. It is their prerogative. They want to have a camp office, they want to have principal office, but they want to have any other office.
We will file the response.
Let us, the judiciary, we should remain aloof, away from the decisions, assuming those have been taken for political considerations, unless we find firmly that yes, such a decision is directly in the teeth of the constitutionality, constitutional philosophy, some part 3 or any other provision of the constitution. There we need to interfere whether it is a political decision or non-political.
My lord, they have not even filed the reply for the Honorable High Court to take into consideration those things, my lord.
Yes.
Without even availing the elementary opportunity.
And therefore, without even taking the reply, the stay has been granted.
My lord, with regard to the communications, for the reason because as per the communication, the chairman has issued a proposal. Now he is saying, and already the state is saying they are in a financial deficit, my lords. So once on one hand they are saying we are having a financial distress, on the other hand they are shifting the offices.
There is no further explanation.
State of Himachal Pradesh is aggrieved by an interlocutory order dated 9th January 2026, passed by a division bench of the Himachal Pradesh High Court, whereby shifting of the office of Himachal Pradesh State Commission for Backward Classes from Shimla to Dharamsala, from Shimla in bracket Kasumti to Dharamsala has been stayed. Next paragraph. Since the issue that arises for consideration pertains to grant of ad interim stay, it is not necessary for us to state the facts in extenso. Suffice to mention that the Himachal Pradesh State Commission for Backward Classes has been constituted for identifying the caste and communities who are entitled, who would be entitled to certain benefits meant for the backward classes. The chairperson of the commission was appointed on 3rd December 2025, followed by induction of members on 23rd December 25. The state government thereafter took a policy decision to shift the office of the commission from Shimla to Dharamsala in Vipet district, Kangra, and to maintain a camp office in Shimla. Next paragraph. Learned Counsel for the Appellant State submits that such a decision was taken in public interest, keeping in view the demographic realities, as most of the backward classes, as the OBC population is largely residing in the lower hill districts, broadly known as Kangra and adjoining area. The shifting of commission to Dharamsala will facilitate the access to the commission, will facilitate the commission to have access to the OBC communities, most of whom live in remote rural areas. Next paragraph. In our considered opinion, in our prima facie it seems to us that shifting of the headquarters of an institute is essentially a policy matter where there is least scope of justiciability, save and except when such shifting directly affects the constitutional or civil rights of the public at large. It is difficult to formulate such an opinion at this stage when the state government has not even filed its counter affidavit. As the matter is pending before the High Court, we do not deem it appropriate to make further observations touching the merits of the case. However, there seems to be no justification at this stage to restrain the state from shifting the office of the State Commission for Backward Classes from Shimla in bracket Kasulti to any place in Kangra district, including Dhamsala. We allow this appeal, semicolon, set aside the intent order dated 9/1/2026. The appellant state shall be at liberty to shift the office of the commission to Dharamsala or any other suitable place, subject to final outcome of the pending proceeding. That's paragraph. The state government or the state backward class commission may file their replies to counter affidavits within a period of 4 weeks. The writ petitions may file their rejoinder if any within 2 weeks thereafter to enable the High Court to decide the case on merits. To enable the High Court to decide the matter on merits, to finally decide the matter on merits. That's paragraph. It is clarified that the observations made herein above are for the purposes of interim stay. So the appeal stands allowed in the above terms.
Obliged.
We may be permitted to give a physical appearance in this matter. We may be permitted to give physical.
You want to file appearance? Sure.
Obliged.
Well, it's item 7. This controversy, my lord, can be traced back to a minor ammonia leak that happens in a French fry factory. My lord, as soon as the incident takes place, my lord, when the incident took place, my lessee was in fact in possession of the property. Thereafter, my lord, soon after, the authorities come and shut down the entire plant. I approached the High Court, my lord, for desealing of the premises.
Why didn't you go to NGT?
My lord,
Why didn't you go to NGT?
my lord, I was impleaded. My lord,
NGT proceedings were there. You got yourself impleaded. Now you open a second parallel proceeding before the High Court.
no, my lord, if I may just correct, if I may just point out this alone. NGT proceedings were so motu initiated and I was only impleaded, my lord, subsequently.
You yourself. So if you had any grievance with regard to the sealing or its import, you ought to have approached the NGT. Skirting the NGT, going to the High Court, isn't it forum shopping?
Well, today I only want one small relief from your lordship's lord. I only want my right before the NGT be kept alive.
So you want to go, please?
I'll go before the NGT. My lordship may kindly clarify that they may not be influenced by the High Court's order.
You don't require any clarification. You are not here before us to seek this clarification. We are not your advisor.
My limited submission, my lord, is that the desealing of the premises can be subject to the orders of the NGT. My lord, tomorrow if the NGT actually, my lord, states that the premises is all the activities are being carried on in accordance with law. Interesting.
So, and
I have no intention of running the unit unless and until I have the blessings of the NGT.
sorry.
I don't want to run the unit. I only want your lordships to say that the NGT may not be influenced by the High Court's order. I'm obliged.
The problem will multiply when the other party comes.
Tomorrow the NGT doesn't find fault with me. I'll have to file another writ petition, Manoj, and get a clarification from your lordships once again.
Maybe
Is my
we
only
can rely upon that we have already, this is a seal of approval of this order.
I'll leave it to your lordships. I'm obliged.
Yes, madam.
These are which matters? These are left out matters.
Yes, my lord. Some matters which remained on that last date, my lords, when my lords were pleased to grant us the absolute bail where my lords are granted interim. These are ED bail in the same matter, my lord, in DMF, wherein the predicate my lords have granted us bail. My lord, the second one is a ground of arrest that we have challenged for Ranu Sahu, and third is a DA case, my lord, in which my lords were pleased on the first day to grant us interim protection because I was already in custody for around period of 2 years.
Are these matters where you came late and we had issued notice on that date?
No, these are matters that were left over, my lords, which could not be heard. These
could not be taken. So I think we'll have different view.
In item 9, is a writ petition. 8, Malas.
Malas, I appear for ED in 8 and 8.5, Malas. Sorry, 8 and 8.1, Malas.
So do you have that old chart which we are having on the, Madam Ashwarya, do you have?
In my matters, Malas, for ED, your lordships may record my objection and I leave it to my lordship.
All right. Yours is item?
8.1, Malas.
8.1.
Yes. 8.1 is arrest, Malas. I think there may not be too serious pressing that. That's quashing of arrest.
My lord, 8.1 is we were challenging the ground of arrest. So my lord, if bail is being granted in 8, my lord, then we will not press that.
Yes. So lordship may record that and then I.
My lord, I appear.
Dispose of 8 and 8.1. In this matter, Malas, interim bail was granted on 29th May 2025.
Where is the note? And is also this Ranu Sahu.
So 8 and 8.1 are Ranu Sahu, Malas.
The ED matter.
Yes, 8.1 they won't press. They are. So lordship may record that. An interim bail, Malas, was granted on 29th May 2025.
My lord, 8.3 is also a bail matter of a smaller player.
8.2.
Come one by one.
So this 3145.
My lords, that is the ED DMF bail. Only formal objection. The interim bail of 29.5 can be made absolute. 8.1 I will not press, my lord.
Anyway, 3145 we will allow in the sense that interim bail already granted is made absolute. So this will be same order as.
Yes, my lord. Same orders.
Where we had earlier recorded Mr. Raju had appeared on that occasion. So same paragraph except that instead of Mr. Raju, Madam Ashwarya will appear. So 3145 is allowed to this extent.
3644 not pressed.
And which one you don't press?
My lord, 3644, my lord. It was in the same matter, ground of arrest we had challenged in the High Court, my lord. Say SLP against that one.
No, 3644.
Yes, my lord.
You don't.
We will not press, my lord, because my lords have granted us bail, my lord.
Say, in view of the fact that while separate order of even date the petitioner has been released on bail,
my lords.
Formal learned counsel for the petitioner does not press this petition.
Most of
accordingly dismissed as not pressed for.
Great.
So now we are left with at serial number 8 there are 2 matters only.
No, my lords, there are more.
No, 8.2 is a writ petition filed by Ranu Sahu, Malas. No notice has been issued. We have not been served, Malas. 8.2.
8.2 is a writ petition, my lord, because I was arrested 3 times consecutively. Whenever my lords used to give us.
We can't issue omnibus direction. It will be very difficult. Tomorrow, if you come assuming, we are not saying about you, but assuming a person, he says, grant me a preemptory bail order, and he commits murder, the authority will be helpless. They will keep on watching there because the Supreme Court has said that no, we can't arrest you. So it all depends upon, we have been rescuing you as and when occasion arises.
My lord, I bow down to that. We only came, my lord, after 2 years, when my lord, on 3/3/2025, in a matter where I was under arrest for around 1 year, 8 months, my lord granted us bail. ED on the same day moved a production, my lord, and then sought my arrest. It is only then, my lords, that because it was becoming something in perpetuity, my lord, because I was getting bail by my lords were kind enough to grant us bail. The next day or the same day, either EOW or ED was coming and arresting us, my
But it
lord.
seems from the variety of cases against you by ED, by Anti-Corruption Bureau, by this.
My lords have been extremely kind to us, my lords.
I think my
Same
colleague should
property.
choose between not pressing or dismissal.
No, my lords, it's writ, my lord. The same issue, same properties is being circulated in all cases, my lord. In DMA.
Maybe obviously because if you have their allegation ultimately is what?
Statement.
That you being an IS officer, you misused your position, abused your power, and earned illicit benefits, maybe through gratification, maybe through shareholding, maybe whatever. These are all set of allegations subject to trial. And you have parked that money in buying some property in your name, buying property in the name of your brother or your family members. So ultimately it is the Indian currency only. They are not talking that you are converting into dollars. It's the same property, same set of allegations.
I am in my lord's hands in this, my lord. My lords may decide it as these are issues that we have raised, my lord. One only thing, my lord, that there were DMs after me, there were DMs before me. Nobody has been investigated also, my lord.
Withdraw this petition saying that you will approach the appropriate form as and when occasion arises.
Permit us to come back also, my lords, if they file another case.
You have been, there is no question of coming back. You have never gone out of the court. You have always been here in one or the other matter. You are always, any litigant who is aggrieved by of an action or whose liberty has been supposed compromised, we never say our doors are closed. You are always,
I leave it to my
will consider act per law. After arguing the case for some time, learned counsel for the petitioner does not press this petition. As according to him, he will approach the appropriate form as and when occasion arises.
My lord.
Ordered accordingly. Now, any other item?
8.3, my lord. 8.4. 8.4.
8.4.
8.4 is a matter where anticipatory bail of Ranu Sahu Malas. My lords were pleased to grant her interim bail on 29/5.
That
in
the matter.
Yes, Malas, in DA case.
So here also you make the same. These also made absolute on the same.
I'm most obliged.
My lord, 8.3 also is the same. It's a Manoj Kumar Dwivedi. He's a smaller player.
Yeah,
he may also be granted.
8.3 is
8.3
Yes, Manoj. Manoj Kumar Dwivedi.
So that's also same.
He was granted.
8.3, I don't know.
8.3 is an ED matter, Lord. Mr. S.V. Raju appears.
ED matter, you are right.
Yes. In that matter, he had asked me to take a passport.
He is not better than.
I get it. The interim order is there already.
The same order. Follow. ये ईडी का मैटर होगा इसमें मैडम ऐश्वर्या का इनका साथ में he is appearing independently. Raju sir.
Yes, Mr.
Raju along with this young man. 8.5 is also there.
8.5, he was not arrested during investigation. He's an excise officer. And my lords have granted bail.
Excise officers order.
While order dated 29/8/2025. Well, he was not arrested during investigation and was granted bail by this court, interim bail. Yes, Malas, interim bail.
Release now.
Yes, Malas.
Say the
same. I need to verify them.
No, this is Vedram Lare, na?
Lare.
So we had passed an order on 23rd September 25. Meanwhile, make it absolute. So we made.
Yeah, absolutely.
So for the reasons recorded in our order dated so and so, passed on so and so day, the interim order dated 23rd September 25 is made absolute on the same terms and conditions which we have imposed in the similarly, in the case of similarly placed petitions co-accused. All right, that is also finished. Any other matter?
Item 9.
Item 9.
9, my lords, I'm seeking 2 weeks' time to file a rejoinder. Their counter has come in only on Friday.
Malas, this is
2 weeks
same
after
matter
that.
as Ranu Sahu.
Hold on, my lords, they filed a counter affidavit. Will come back.
This same. He's seeking similar omnibus prayer, Malas.
I want to file my rejoinder, my lords. I don't know why should there be a problem with that.
A similar
Lordships
matter
have
has
issued
been.
notice, my lords.
Prayers are
It takes
similar
them 2
to
weeks
that
to
as.
come back in my this thing, my lords. They filed a counter on Friday.
You can approach the appropriate.
No, my lords, I've already approached the appropriate forum. I've come not in a direct 32 here. I've come against a 226 dismissal. So please give me 2 weeks, my lords. I'll come back in my rejoinder also. There are some new facts that they've taken. We'll respond back. So after 2 weeks, if your lordships will have.
No, the impugned order is declining bail or
My lords, my
application way that
is rejecting. Alternative remedy 1, and then second saying that you should have either filed a quashing or you should have filed a anticipatory bail. Now neither of them in my case will apply, my lords, and I'll point out why. I'm just taking 2 weeks time, my lords. If your lordships will accommodate me only for 2 weeks.
So let me take up on Friday. What about time?
My lords, in item 10, I am seeking a pass over, my lord. Item 10, I am seeking pass over.
Small player,
Maya warrior. He can also be granted. He is there for the ED.
ED Lordship, I am appearing. I am led by Mr. Raju.
So he is a very small player as compared to.
Yes, but Lordship, if sees the prayer B does not exist because prayer B was not there in the special court's order. So prayer B does, because Lordship, the order that was granted bail said the conditions will be imposed by the special court. Special court has not imposed any condition that is pleaded in prayer B of the IA. So prayer A, I leave it to your Lordship if Lordship wishes, but prayer B doesn't.
more conditions to be imposed, sir.
That all in very stringent conditions we impose.
Yes, but Lordship, I am saying.
Those conditions will apply here also.
Yes, but Lordship, if only comes to page 5. Prayer B says, direct the petitioner to report to the concerned police station, EOW, ACB, Raipur or any other police station once a month or fortnight. That condition was not imposed by the special court. So the condition that she is asking for waiver of is not in existence. That's what I'm pointing out.
Now, what is prayer number 5?
Prayer, page 5, Lordship comes to the IA for modification of bail condition.
Prayer B.
What is it?
There is an IA.
For modification bail conditions.
Report to the concerned police station.
Yes, this condition was never imposed by the special court.
This was never imposed, so this is infructuous. No, sir.
Yes. Lordship will find the conditions that were imposed in page 13.
My lords,
No, but where is this condition imposed by us? In the order of 6th of October.
Yes, Supreme Court by order dated 6th of October said conditions will be imposed by the trial court. Lordship will see that in page 9 of the same IA. The Lordship will see the conditions which were actually imposed by the special court in page 13.
No, but 6th of October is very short order by us.
13, 14 years of conditions imposed.
These are conditions imposed by the trial court.
Yes.
There is no condition of meeting the investigating officer.
Reporting. Which is the condition this one?
Sir, stay outside, stay away, submit affidavit, surrender his passport, and so on and so on.
Yes.
my lords, I
Mechanically it has come.
For the enforcement, after hearing Sri Raju along with one, so on behalf of the Enforcement Directorate, from the interim order dated 6th October 2025 is made absolute, subject to the same terms and conditions as have been imposed by the special court, special judge.
Special Judge Dhan Sadan
This place,
6th Additional Session Judge, Raipur, Chhattisgarh.
Special Judge in bracket Money Laundry Act, 6th Additional Session Judge, Raipur. Wide order dated so and so.
7/10/2025.
70.
Order dated so and so.
1720.
Grateful, Lords.
Please.
Now your matters are over. Please. Chhattisgarh.
One item is there. Please, Lordship.
14
is still left.
14. Okay. We'll see. Just in 2 minutes we are reaching the 5 minutes. Item 11.
11, I must at the outset apologize. My counter was filed a little late, but I have copies, my lord. I filed a counter for the state.
In item 11?
11.
Counsel for the state of Maharashtra state flat. Counter affidavit has been filed, but the same is not attached to the, is not tagged with the paper book. Registered to do the needful. Next Monday? Next Monday.
Next Monday. I'm
Post the matter next Monday.
Very. I'm grateful, my lord.
My Lord, one request, my Lord, if possible, may be kept on 18th. Monday, 16th. 18th is if possible.
All right, sir, we will comply with your direction. 18.
I'm grateful, obliged.
Yes.
Item 12, my Lord.
Item 12.
12. Charge sheet was laid, my Lord, in the year 2023. I appeared before the court, coming up after notice, my Lord. I appeared before the court, executed the bond. Subsequently, on an application filed by defective complainant, one more charge was added. Therefore, my Lord, my bail bond was cancelled. I moved for anticipatory bail. Sessions Court granted anticipatory bail. The Honorable High Court reversed it. So against which I am there. 2023, my Lords. Violation of trademark.
Your anticipatory bail was cancelled. We have stayed that order.
Yes, ma'am.
He wants to make it absolute.
Granted.
My lord, they have not only misused my company's name, they've been selling poison to the public. High Court in its order, my lord, High Court has clearly said, where is that order? That is page number 198 of their SLP, my lord. High Court says that when they went for testing, they were absolutely unsafe for human consumption. My lord,
That's right. That for that, whatever the trial will take place, and if they are found guilty, obviously they will face the.
I say, my lord, the bail was granted only on the ground that overlooking section 467. They said all the offences are, I apologize.
The best course for the state is that the powers are very well there. They can seal the premises. They can close the premises where it is found that what is being manufactured is basically a poisonous substance. They can always do that. There are other provisions. That does not mean that criminal case will not continue. Criminal case will also continue. But for that preventive measure, they can take other steps.
My lord, High Court has said that you surrender and apply for regular bail.
State, and we hope that the state will.
Madam, I'm very for a state, my lord. My only the legal submission is that once they have appeared and took regular bail, then the question of anticipatory bail is not there. They should go and take the regular bail. Who is going to stop?
Cancelled. Therefore, we
have heard learned senior counsels to counsel for the parties. It seems to us that there do not exist sufficient and valid grounds on the basis of which the High Court could recall the order granting anticipatory bail to the petitioner. आपको लीव करके कर देना कि वो order satisfied करना. Consequently, the appeal is allowed. The impugned order dated 17 December 25 is satisfied. It is directed that the appellant shall continue on bail, subject to same terms and conditions as already imposed during the pendency of the trial. Next paragraph. It is, however, clarified that the granting of anticipatory bail shall not be an impediment for the competent authority to take other preventive measures against the industrial unit if it is found that the product contains any poisonous or unhealthy substance. We have clarified that. Now we can.
Take it. No problem.
Safety law को करना, food safety law में करना,
आपको under the
FSSAI.
describe the total.
I will come from that section. Next year, that's why I got that. Okay.
Please, my lords. My lords, please, my lords. Yes, despite this vicarious liability, my lords, I just explained that I've already undergone 9 months, my lords. If it is considered under section 26, that is violation of conditions of license, the maximum punishment.
Who is the person from the respondent?
Don't argue that, sir. Don't argue all that drug and cosmetics.
Please, my lords. I'll argue on merits.
That to your
Kind of medicine your partner is recommending, it is not under the drug and cosmetic.
Yes, ma'am.
Very easy to see.
No, I'm talking about 26 only. But NDP is 26. But on that, my lords, I'm not leaving that for the moment. On merits, my lords.
No, we
Who is
followed
appearing
the
for this service? They could.
Dr. Malhotra had requested.
Yes, he is true, my lords. And he was running. I'm only a silent partner.
But we are surprised doctors are doing.
But Lord Siraj, kindly see, there was no animus because in fact they are searched.
In Punjab,
it's a malice. It has to be.
Drug mafia includes.
Yes, it's a mafia.
People are making lucrative money. The doctors, the so-called industrialists, the police, and so many people are hand in glove. Unfortunately.
But one interesting thing, my lords, why this Malhotra might have done it, because the search in the pharmacy took place on 28th. Then thereafter, the search here took place on 2nd, next month. So even knowing that the search took place in the pharmacy, these people thought that this is nothing illegal here. Otherwise, they would have removed it. If they had some idea, Malhotra on paper, no person with a reasonable sense will not order for
Let us not open our mouth because it's for the prosecutor to make the case.
Absolutely.
But this was under the cover of using it as a medication. They were dealing with a Schedule H drug for which even the hospital does not have the license.
Deeply obliged. Return of some early date may be given.
Trustee also.
Deeply obliged.
Notice देना है ऊपर देखिए
पहला फर्दर वाला है सर
Yeah.
14 है ना
I'm the petitioner. Lordship, in item 14, but not like 1 and 1, but for the state.
I'm there in 1.
Password? No, not a password. Not a password.
14 का नंबर है, देखा कैंसिलेशन हो ये वो दूसरे वाला है सर ना 14 पहले 14 वाला बेल पे देखा सर उसके सर ये ग्राउंड्स पे बेल मिली है सर डिटेल ऑर्डर है सर वो कहते हैं कि नोटिस इशू कर दो नोटिस इशू कर ये बोलेंगे ना उसको स्टेट ऑफ छत्तीसगढ़
We'll take up this matter after some days.
at least notice may be issued.
No, my lord. I have serious objections to this. This was argued at great length. Your lordship will see the orders. Every contention has been considered.
Well, that's my whole case. I'll point out in two.
No, I'll also point out.
Notice again delay, my lord. At least it should be issued. I'll point out that none of my arguments have been considered. And my lord, there are some propositions of law, with the greatest respect to learned judge, my lord, which are not tenable.
It's a very detailed order.
Your lordship will see. 50 pages.
It's not a detailed order.
Can't be not a regular.
How can?
Against a bail order. It should be a ground.
It is not a detailed
So now every order will come on an appeal like this.
59 pages of narration of facts.
Coming in every case, this
Every aspect was considered, my lord, and at length for many days.
I thought it's my petition, my lord. I should be.
We are opposing your petition.
Of course.
By saying this is the attitude of
Yes,
the
yes, but I am. We'll show your
the
attitude.
first case, my lord. The lordship has done, my lord, so many of these cases.
Today, for some reason, we are not saying anything for today for some reason.
Very well.
We'll take up this matter after a week or so.
Yes. After 2 weeks, my lord, I have some difficulty. After 2 weeks.
My lord, because this man has been released on bail, a vital witness is not attending anymore.
My lord, that in fact is an issue which needs to be.
Called Manav Saxena. Well, I'll point out what kind of.
You can bring those, so if any subsequent events.
Yes.
Because 2nd January means now more than 1 month.
Yes, we will bring
If there are any visible subsequent events, you can place on report.
So, the main ground that vitiates it is, my lord, that this man's name was not mentioned in the FIR, therefore it should be granted.
May I draw your lordship's attention, my lord Chief Justice. My lord, in 14.2, this is that lady Soumya Chaurasia. Soumya Chaurasia. My lord, she has been granted interim bail in a large number of cases by your lordship. My lord. She has spent 2.5 years in jail in and out. Your lordship asked her to stay out of the state. Now they have registered a fresh FIR in December this year, again relying upon material of 2019, and she is arrested. I am requesting.
But December is much before we pass this order, last order.
Not fresh FIR.
December means much before.
No. I am old. Arrest is in December. She has been arrested now in December. My lord, I am praying for interim bail. My lord, she has been granted interim bail by lordship over the last 2 years.
But filed some petition, Mr. Rowe.
We have filed. It is listed 14.2, my lord. Notice was issued by lordships.
14.2 and 14.3, Mr. S.V. Raju appears as taking a passover.
In that liquor case. This is ED liquor.
14.1 and 14.2.
One is unrelated.
This is the 6th time she is arrested. 5 times I have got.
14.2 is a writ petition under 32.
Yes. But I am saying this is not a evergreening of arrest. How many times, my lord? 22, 24, 25. 6 times the lordship granted her bail.
It's a writ petition. Anyway, there's no requirement to serve.
My lord.
Pick up your matter within a week. You file a petition there. The instant writ petition under Article 32 has been filed.
Lordships have granted
by the petitioner.
Notice issue.
Questioning the vires of Section 44 of the MLA. However, we find that in substance, the petitioner is seeking her release on bail in a matter in which she has been arrested on, what is the date of arrest? On 16 December 25. In relation to the liquor scam, has been arrested by Directorate of Enforcement in relation to liquor scam. Since the primary relief sought by the petitioner pertains to grant of bail, we relegate her to approach the High Court of Chhattisgarh. It may be Chhattisgarh. The petitioner, for my so advice, may file a petition. Within 1 week.
Yes, immediately.
In 1 week, the High Court is requested to take up the matter on out-of-turn basis, on priority basis, and make an endeavor to decide to decide at the earliest, but not later than 2 weeks.
I'm very grateful.
But not later than
Very grateful.
The High Court will also keep in mind the various orders passed by this court granting bail to the petitioner and other co-accused. This order.
14 and 14.1.
My lord, she has also been arrested by EOW now. So, my lord, your lordship's my lord, observation may apply, my lord, there also.
She has been arrested by now by EOW.
My lord, this was ED, what your lordships have dictated.
Instead of ED, then
this was ED. Now, my lord, after that, she has been arrested, my lord, by EOW on 2nd of January 26.
It seems that the petitioner has been further arrested in another case by
EOW, Chhattisgarh.
Economic
Offences wing.
So and so. Then the petition may apply in both the matters.
Correct.
Then
I'm very good.
So my lord is placing 14 and 14.1 together on a separate date?
There's no connection, my lord, please.
No, there's no correction, I agree.
You are going again.
14.1 was in relation to the evergreening of complaints, my lord, again and again, without seeking permission of the court. There was a point of law in that your lordship had.
No, this is the first time I've heard of accused who themselves evergreen, now accusing the state of evergreen.
That is ED.
Yes.
That's ED, sir. You're not in that.
No, no, it's therefore.
In
Evergreen.
14 and 41, we can take together.
Can it be after 2 weeks, bro?
After 2 weeks or 10 days, give a day.
So grateful.
Both matters are 14 as well?
Both.
14 and 14.1 is filed by you.
Yes, bro.
That is ED matter.
That is the ED matter.
That is not your case, Mr.
That's
Jatnai.
14.1, but your lordship may keep them on separate dates.
No, 14 and 14, but don't tag them. Don't
tag. That's
all right. 14 or 15 like this.
Yes.
And be tagged and listed separately, but on the same day.
So grateful.
Obliged.
Grateful, lordship.
Please, my lord. Lord, pursuant to your lordship's order, my lord, of 27th of January, there is a fact-finding report, my lord, that the loss caused is only 3 lakh of rupees. And the penalty sought to be imposed, my lord, is 12 lakhs, my lord. We leave it to your lordship's, my lord.
This item 15, are you referring to?
Kindly have your lordship's order, my lord, of 27th of January 26, my lord. Last order. Issue notice. Meanwhile, interim anticipatory bail is extended. However, Chief Secretary are directed to submit a tentative fact-finding report with respect to the loss caused to the state revenue, including in terms of the value of the illicit transported minerals, which is attributed to the petitioner. It is made clear the continuation of the bail will depend upon it.
Well, is there any report filed?
Lord, yes, Lord. We filed that report, Lord. If your lordship has the fact-finding report, in this span of 2 months, Lord, he extracted about 4,314 tons of illegally mined minerals. And the total penalty which the state is to recover from him is about 12 lakh.
According to you, the loss is 12 lakh.
12 lakhs, yes.
7,000.
This is the penalty, Lord. But this is apart from
Loss
the
is
fact.
3 lakhs. Loss is 3 lakhs. My penalty is 4 times, my lord, the loss. That your lordship will
You
get.
can afford to deposit without prejudice to your rights.
Lord, this is only
Lord,
small.
this man is a habitual offender.
Transporter, my lord,
There is sometimes a presumption. The presumption is that the litigant who can afford to engage Mr. Devdutt Kamath,
my lord, I'm sorry.
seems to be having capacity enough to deposit this fine amount.
Lord, he's a repeat offender, Lord. Earlier also, a penalty of 90 lakhs was imposed on him, Lord. Not only that, he was absconding. We had to issue proclamation notices.
Nobody
He's a flight risk as well, Lord. So I was only wondering, Lord, whether we lordship would ask him to, now that the charge sheet has been filed, and the charge sheet discloses, Lord, the charge sheet now discloses that he used fake e-Ravanna papers, Lord, to transport.
Lord, I have lot to say on the charge sheet. Give me a.
No, charge sheet has been filed.
Charge sheet has been filed.
So the petitioner was denied pre-arrest bail, anticipatory bail by the High Court of Uttarakhand, while the impugned order dated leave granted. The appellant was denied anticipatory bail by the High Court of.
Lord, he was granted anticipatory bail, but only for 2 weeks. He was granted anticipatory bail, but only for 15 days, so that he could seek regular bail. That was the bail. That's the
That is completely contrary to lordship judgment.
Say like this, the High Court of Uttarakhand, while the impugned order dated 30th December 2025, granted anticipatory bail to the appellant in case number so and so. However, limited the operation of that protection to the extent that limited the operation of that protection for a period of 15 days, meanwhile granting liberty to the appellant to approach the jurisdictional court for grant of regular bail. The aggrieved appellant has approached this court. Then say on 27th January 2026, the following was then say in reference thereto, a fact-finding report has been submitted by the authorities, according to which the appellant is alleged to have caused total revenue loss of rupees 12,07,927 only.
Plus 3 lakhs is the loss. Penalty, they say, comes to 12 lakhs. Loss is only 3 lakhs.
So, has caused loss of 3 lakh to the revenue.
No, that is not our
penalty of this 12 lakhs.
Page 6, of the
Next paragraph. It is not in dispute that investigation is complete and charge sheet has been filed. So that being so, we are of the view that the appellant can be allowed to continue on pre-arrest bail, subject to however is depositing the amount tentatively levied, the amount tentatively levied. The fine and penalty, subject to his deposit of the levied amount of fine and penalty. The appellant will deposit the requisite amount within 2 weeks. Within 2 weeks, without prejudice to the rights of the parties.
Yes, ma'am.
Next paragraph. The appellant shall be at liberty to challenge the levy of penalty or the levy of fine or the penalty before an appropriate form in accordance with law. Next paragraph. Similarly, the deposit of fine or penalty shall not absolve or exonerate the appellant from the penal consequences, if any, and so all these issues shall be, if any, and thus the trial court will proceed against in accordance with law. The trial court shall proceed in accordance with the law.
Lord, the conditions imposed by the High Court will continue, Lord. So, Lordship may the conditions imposed by the High Court for grant of bail, those will stand incorporated by your Lordship's order as well, Lord.
The appeal
on the same condition.
From change order of the High Court is set aside.
Lord, the only request is whatever your Lordships have said
is allowed in the boardroom.
Whatever your Lordships have said, my Lord. Lord, my Lordships may say that not affect the merits of the case, my Lord, because ultimately
goes without saying.
Clarified that we have not expressed any opinion on merits of the case.
Extremely grateful.
I'm grateful.
Item 16.
May it please, Lord said directed me to inquire about the antecedent of this the petition. Well, there are none.
No antecedent.
That was the only.
No antecedent. He got money in respect to online fraud, but
The appellant is aggrieved by order dated 11/12/25 past 12. The High Court of Chhattisgarh at Bilaspur, declining in bail in FIR number 157/2025, registered at Police Station Raipur under section 111, 317 in bracket 2 and 317 in bracket 4, 317 in bracket 5 of BNS 2023. The appellant was arrested on 6/10/2025. The allegations are that during the period 26th June 2025 to 6th July 2025, the appellants co-accused, Honorable Vishal Bekra, operated multiple bank accounts through which online fraudulent transactions aggregating approximately rupees 9.45 lakhs were received. The appellant is alleged to have assisted the above named co-accused by providing a mule account, and he received a share of the proceeds in cash. Next paragraph. Having regard to the nature of allegation and the period spent by the appellant in custody, or without expressing any opinion on merits, the instant appeal is allowed. The influence of the High Court is satisfied, and the appellant is directed to be released on bail, subject to his finishing bail bond to settle the trial. He is good picture. The back of the bail appeal. You are still NFP?
No, my lords, I'm in custody, my lords.
No. If suppose you like the jail premises or the jail atmosphere environment, then we can dismiss the petition. We can allow you to stay in jail if you want. Otherwise, we have by mistake granted bail to you. You want to be on bail or you don't want?
My lords, I want bail, my lords.
And then you should go by with a smiling face from court. Why you are so showing as if you are under depression?
Okay.
Thank you, young lady. Thank you. Item 18.
My lord, item 17, my lord.
Just 17 minutes.
My lord, 17, my lord. I am praying for bail, my lord.
17. Thank you. Or 17 also.
Yes, my lord.
Oh, you are the main accused. This main
He's
accused.
the main accused, my lords.
My lord, I am.
My lord, इसको bail दे दो.
My lord,
अभी तो छोटी मोटी चोरी केस है.
The child, same reasons, my lord.
my lord has granted me bail.
अरे दे दी भैया बेल दे दी. साहब आपसे डर लगता है पहले. Item 18.
But bail was denied to me while granting bail to others. For me, my lord, bail was denied because I happen to be closely related to A7. So he is absconding, he applied for anticipated bail dispute. That is the only reason given. Your Honor, kindly come to pay 31. Long incarceration.
The main.
Clearly, how much you have made money, sir? As per the allegation?
732 crores.
Only.
A7 is the shell company. Owner
Your
of
Honor,
the
kindly come to page 31, my lords.
not
But long incarceration is the only ground.
9 months only.
My lords,
9
10 months
only.
now 10 months, almost 10 months.
For 700 crores, 9 months.
Look at
That is
the
what they say. I do not want to go into the merits of the matter now.
Look at the eminent position and the seat of power you have enjoyed. There is a direct nexus between the allegations attributed to you and the position you held for a long time.
But I will.
And you are not an ordinary and small kind of person.
But
And after investigation, there are definite allegations against you of taking a huge amount of bribe and
I will not.
visible in your accounts or in your known sources.
But at this stage, I do not want to go into the merits of the matter. At this stage, but I will argue the matter on merits when they file their counter. Now, for the present, I would submit. All the other accused, most of the accused are similarly placed to granted bail on the same ground.
We have also granted. We have granted bail. We are aware, but not. Those were very, very small fry.
No, same thing. Same as accused number 34 is concerned with the similar or graver allegations. All. Almost all according to the case, all acted.
The order. Page 31 of the order.
Not only me. The others also similarly placed. They have been granted bail. Yes, Murad. Yes, Murad. But so far, accused number 1 is concerned, closely related to determining factor, closely related to A7, who is absconding now. Another influential supervisory role. That's all. For the next man, investigation substantially complete, no direct recovery, risk of absconding or tampering not shown, role more facilitative than controlling. Then next man, my lords. Investigation complete, co-accused with similar or graver allegations granted bail. Prolonged detention would be pre-trial punishment. Same. The next member charge.
You are the central conspirator, first of all.
No, I am.
Central conspirator.
Your Lordship,
Orchestrated liquor policy, influenced obvious allocations, promoted blue-eyed brands.
Your Lordship, kindly come to.
Selected kickbacks of 50 to 60 crores.
Your Lordship, kindly come to Murat's page, paragraph 44, page 24. Murat, the allegations against me have been almost similar allegations against others also. Charge sheet has been laid. I have been in prison for 10 months.
No, allegation against him 732 crores.
That's right. Your Lordship, kindly come to paragraph 44 of the order, page 24.
Nagamothu,
My lords.
the shell company in which 750 crore was parked, as per paragraph 45 you indicated, is in your direct control through A7.
No.
This is the prosecution case. Now, if you accept that, you stand clearly on a different footing to A6, A34.
I will show Mulat the other accused for whom bail was granted. Mulat, the graver offences than me. Mulat, they are also for the present. Mulat, my submission would be Mulat. Mulat, let them file counter. Mulat, I will take your Lordship, Mulat, and place records also to show that absolutely, Mulat, there is nothing against me. Mulat, and these allegations are very minor.
At best, you can make out a case for cancellation of bail granted to some others. But that will not help you in getting bail.
But that matter is pending before this honorable court. Your Lordship, kindly take this along with that. Your Lordship, kindly see, in respect of some other accused, bail was granted, challenged before the court, pending. Your Lordship have granted stay of that. High Court cancelled. Your Lordship have granted stay. That is also pending before your Lordship.
No, those were
that matters disposed of. They have disposed of.
There was question of statutory bail. We said that without going into that question, they will remain on interim bail and the issue will be decided on merits.
If your Lordships decide to go into the merits of the matter, I may need some time. Kindly have it this Friday. I will argue elaborately. I do not want to waste the time of this on today. Kindly have it Friday. I will argue elaborately and demonstrate.
How does it matter, Mr. Nagamothu?
My lords?
Monday or Friday, how does it matter? You can argue today whatever you want to argue.
Today, kindly consider to take.
We are not inclined to release him on bail at this stage.
If you want
to argue on merits, you are welcome. We can't stop. But please, you will not invite any observations from us on merits also. Today, we are only simply to say, at this stage, we are not inclined. After the examination of some of the vital witnesses who have direct bearing on your accusation against you, liberty to apply afresh before the High
kindly, at least kindly have it tomorrow. I will argue the matter elaborately. Kindly, for my sake, kindly have it tomorrow. I will argue the matter elaborately. Tomorrow, at least. Or subject to my lord's convenience any day. Any day subject to my lord's convenience. Tomorrow is interest for your lordship. Kindly have it any day. I will argue the matter elaborately. Any day. I am not asking for any day. Any day, Friday, this Friday, subject to my lord.
Friday will not Friday.
Any day, subject to my lord's convenience.
Before Friday, you tell us over. Day after? Wednesday?
Tomorrow.
Day after we are arguing.
Day after tomorrow, I'm not here.
On Thursday?
Thursday.
All right, Thursday.
Thursday. Good.
Yeah, that's it.
Now, Lord, this is a case, Lord, where a closure is ordered of a chemical factory. Now, Lord, this is not a case where the factory is deficient in any manner. We are functioning for 10 years. We are fully compliant. The allegation is that, Lord, we have to dispose of spent hydrochloride acid. which we use for manufacturing, my lord, an intermediary product.
There, Mr. Rodgi, deputy. Uska-
We're discharging the acid in Narmada Canal.
In the Narmada Canal.
So what has happened is this, my lord. My lord, I have to use an approved vendor, which is, my lord, a transporter, approved by the Gujarat Pollution Board. I can't use any truck I like. I have been using an approved vendor, my lord, for 5 years. They have made more than 500 trips. There has never been a problem. It has to be disposed of in that man's factory, my lord. That's how the hazardous rules provide. Now, my lord, I accept what has happened. Apparently, this driver on this trip did not take, my lord, the product to the factory concerned for disposal, which has been going on. Apparently, my lord, the allegation is he disposed of in a canal, etc. Now, if that is so, my lord, there can be some penalty. The penalty can't be that you, my lord, throw the baby with the bathwater.
We are not saying that
What wrong has I done? I have chosen, my lord, a vendor approved by you. The driver went elsewhere.
The point is, Mr. Rodgi, that whatever mechanism you had for disposal of
yes,
that has been found to be faulty.
And, my lord,
Mr. Rodgi, please see,
it is GPS enabled.
It's a question of life of millions of people.
I agree. My lord, I can show you. Show me the
only source of drinking water in that space.
my lord, I am not saying no. I am saying, my lord, if it has happened, the remedy can't be closure.
We are not saying that. Your remedy will be that you will have to satisfy the NGT that what kind of preventive measure you will take. It will be a scheme.
Show me that. My lord, show me that movement. Physical movement.
So page 7.
My lord,
Page 7.
my lord, your lordship is perfectly right. I will show you, my lord, that there is a live GPS of every truck with this number moving, my lord, on a screen, going from A to B. When I saw it myself, there was some diversion, my lord, of that truck. That is, my lord, this is how it is done by GPS.
This you can show to the NGT also.
No, I only wanted to say, my lord, this man may be remiss. This is how, my lord, it goes. This man may be remiss. 1 out of 500, my lord, trucks may be remiss. I am not saying no. But the remedy can't be to order a closure of the factory. You may have some penalty, something. I can understand.
We are not saying at all that what should be the proportionate person.
Correct.
You are entitled to argue on the doctrine of proportionality that you can, but you can argue it before NGT.
Proportionality, I agree, my lord. Proportionality is if I have committed something wrong. My lord, I have chosen a vendor. What else?
Under the hazardous rules, Mr. Rodgi, it is the vendor is considered to be your agent under the
But approved by them.
extended product liability.
Correct. But approved by them. What else can a man do? My lord, some penalty, yes, but
The Honorable Chief Justice indicated to you that it is a question maybe of proportionality in the embargo or the interdict.
if I am remiss,
That is to be examined by NGT.
Once you will submit a scheme to the NGT that yes, this mistake or lapse has happened, but to prevent it that and to ensure that there is no violation in future, this is my scheme.
and this is what I am doing, my lord, for the last 10 years.
The tribunal will consider that.
Only one more request. My lord, now the order has come. That day the order wasn't there when he mentioned, my lord. The order, my lord, of the High Court has come now. Have a look at that. See the last portion. I want to make one submission there. I filed that order separately, my lord. It wasn't there.
It's impugned.
It is now impugned. Yeah.
Part of the
See page 15. Last portion, my lord.
para 23. Yes.
Yes. Liberty rests with the petitioner to approach the pollution board for seeking
State pollution control.
Yes, to seek revocation or go to NGT, my lord, and these observations will not come the way, etc. Now, I only want to state, my lord, on 5th of February, I have gone to them. That, my lord, representation is pending.
We can direct them to decide.
Only one thing, my lord. Till then, the closure, my lord, should be in abeyance. Why should I be closed?
That part.
So even if you decide in 1 week, my lord, your lordships consider a man who's not remiss on his own factory is not remiss, my lord.
You simply tell us that have you approached the state control?
Yes, I have approached them on 5th of February, the Chief Justice on Friday.
No, we can simply direct the board
Yeah.
to decide that matter within a week.
After giving me an oral hearing, my lord, I will show them this.
Of course.
Number. But till then, my lord, there should be no coercive steps. My lord, what is the advantage? I produce, my lord, for anesthesia. I give it to the government. I give it to all that. There has never been, my lord, a remiss position of this factory for 10 years.
You see, sometimes the harsh actions are required to be taken to convey a very stern message to everyone.
I understand
But
that.
you can't play with the environment like this. That is only maybe.
But my lord, to paint me black because one black sheep may have been remiss is too harsh, my lord, for a closure. I employ 500 people, my lord. I have never been remiss. There is not a single instrument, my lord, equipment which is not installed. Consider, my lord.
They can consider the main matter.
Just consider this, my lord. Every day, your lordships have cases where there is affluent flowing from factories.
Operating a manufacturing unit at the Dahej in Recruitment, Gujarat. The spent hydrochloric acid,
Yes, spent.
in bracket spent HCl, is generated by the petitioner's industrial unit as a byproduct. According to the petitioner, that spent HCl is supplied to an authorized actual user. However, on 29th January 2026, a tanker bearing number GJ-27-TG-6676 loaded with 34.170 metric ton empty of spent HCl which departed from the petitioner's industrial unit, a factory, on 30th January 2026. Was found to have thrown that spent HCl in Narmada Canal. This prompted the Gujarat Pollution Control Board
Only for
take an action under section 33 capital A.
only one interruption, Lord. They gave me a show cause notice asking for a reply in 3 days, but without waiting for that, they closed me the next day.
We also closed the other side, the other entity where they were receiving HCl. We found that they have not received HCl. What happens is for them it's a byproduct. For another company, it is a raw material.
But Your Lordship may say it's an allegation. I don't admit that he has done this, he has done that.
Pollution Control Board is said to have found from Messrs. Sri Ramnath Chemical
Yes.
that the spent HCl was not received by them. The spent HCl in a roasted truck was not received.
Lord, we dispute this proposition. We dispute this. That it was diverted or that, Lord, he didn't receive it. I dispute it.
Was alleged
I'll show it.
received by them. There is further allegation that it was thrown in Narmada Canal. Be that as it may, the Gujarat Pollution Control Board issued a show cause notice and thereafter has passed an order.
Issued a show cause notice for 3 days, but
Lord, they did not wait for my reply. They passed the order the next day. That is one breach.
Invoked its powers under section 33 capital A of the Water Prevention Bracket 33A2
Yes.
of the Water in Bracket Prevention and Control of Pollution Act 1974 and issued a closure order dated 3rd February 2026
to avoid grave injury to the environment.
On the ground of avoiding grave injury to the environment. Next paragraph. The above stated order was challenged by the petitioner before the Gujarat High Court, before the High Court of Gujarat However, the writ petition has been dismissed by the High Court, while the impugned judgment dated 5th February 2026 with the following liberty. Reproduce para 23. Next paragraph. The agreed petition is before us. At the outset, it is pointed out by Sri Mukul Rohtage, learned senior counsel for the petitioner, that in deference to the directions contained in deference to the liberty contained in para 23 above, the petitioner has filed a statutory appeal.
No, my lord, a representation.
Petitioner filed a reply to the show cause notice cum representation.
No, actually, my lord, show cause is now over. I made a representation on 5th of February before GPCB, on 6th of February.
I made a representation to the State Pollution Control Board seeking recall of
Revocation. No, it's called revocation. Revocation.
Revocation of the closure.
Seeking revocation of the closure order dated 3rd February 2026. Yes, sir. That being so, comma, we deem it appropriate to dispose of this facility